Okay, so hello and welcome to our special two-part virtual training series on local government law, where you'll receive a concise overview of the legal aspects of being a local elected or appointed government official. The sessions are based on select chapters from the book, Local Government Law, a practical guidebook for public officials on city councils, community boards, and planning commissions, authored by our presenter, Jerry Fisher. Jerry is a well-known and respected land use attorney with decades of experience working throughout Southeast Michigan. So before we get started, just a few housekeeping items. I just want to remind everyone we're recording the session. I'd also like you to direct your questions using the chat function in Zoom to Jim Schaefer. Jim will monitor those questions and we'll hold a Q&A session after Jerry's presentation. So let's get started. Please help me welcome Jerry Fisher. So Jerry, you can go ahead and share your screen and we'll be on our way. Thanks.
Okay. So I'm going to assume, unless people tell me otherwise, that everybody can see the screen. Welcome to everyone, and 1,000 hellos to everybody that showed up here today. And thank you for allowing me to share your lunch hour. I much appreciate that Jim Schaefer hatched this idea of doing the program. Of course, my good friend and planner, Dick Carlisle, characterized this program as a shameless effort on my part to sell books. But the truth is that this is purely a labor of love. And the important thing is that local government officials and local governments have always been critical in the American system of government, even before the United States was in existence. And local officials can really do astonishingly great things for their community. And so my goal today is to provide everyone with basic principles that provide a practical understanding of each of the three topics that we're going to cover in this section, with the ultimate point of that it will enhance your ability and therefore your enjoyment to serve local governments. So let's begin.
Bingo.
Great. All right, so just what is a local government? I think that's a good place to start this whole program. It's just, there's a business of local government, just like there's a business of state government, a business of federal government, and of course, the overall system is federal, state, and local. And officials take office and get hired or elected, and it's not clear in terms of what their boundaries are, and that's an important thing to know in terms of being efficient, so that whatever you do, you're in the right place. And so we don't know the limits of what your government does and has the authority to do. So the reason why there's a split in governments, we basically have a two-tiered system, federal and state, with local governments being part of the state government. And the purpose of that is to provide a check and balance to avoid the concentration of power at one level. Remember, when this system was created, there had been monarchs that created problems, and so there was a desire to avoid all that concentration of power. So this was separated. And as an aside, there was a separation of the federal government power, which was then carried over to state government as well, in terms of judicial, legislative, and executive, all being checks and balances to avoid too much concentration of power. So how is the power divided between the federal and state governments. And that's a really interesting thing. The federal governments have limited power, theoretically, within those bounds actually enumerated in the Constitution. So the idea is, in theory, that you can go to the Constitution, see what the Constitution gives the federal government, and that's all they can do. And the rest belongs to the states and the people. So the federal government is, in the Constitution, is delegated the authority to provide for the defense of the country, regulate commerce, establish a post office, and these things. And the state government, local government, state and local governments can't do any of these things. Now, state governments, as I mentioned, have like everything else, like all the remainder of things that the federal government hasn't been given. That's in theory. And so states can't act like the federal government, can't coin money, can't, without the federal government's permission, engage in a war unless actually invaded or faced with imminent danger. Now, this theory is all fine, but there's been an erosion of that, as you probably were asking yourselves, how is that possible that there's this nice sharp division here? The federal government has been taking over more things over time, gradually, and sometimes in fits and starts. One method that is used to accomplish this encroachment of power is the courts have given the feds the authority to go into the state's areas incidental to funding. So as an example, a striking example, actually, education is a state function. But here we have a cabinet level Department of Education. And how is that possible? It's because all the educational things are done in connection with funding, or as a condition of taking this funding, the federal government is going to do this, this, and this. So that's why you can't see any sharp lines as initially envisioned. Very important for our purposes today is that the states and the feds have, states, not the feds, have police power. And that is the power, I'm sure you've heard of the police power, the power to protect the public's health, safety, and welfare. And for that, you can think in terms of such things as zoning, health regulations, and the like. And along with the power to tax and so forth, and education, the police power is probably one of the major sources of authority to protect people and promote quality of life. So where do local governments fit exactly in the overall system? First of all, let me reiterate that local governments are really part of the state government, sometimes referred to in state laws as local governments are subdivisions of the state. But the Michigan Constitution does not carve out established areas of power for local governments in relation to the state. As you remember a moment ago, I mentioned that the federal government is supposed to get those things actually enumerated in the Constitution. State and governments and the people get all the rest. Well, that doesn't apply at the state level. And in fact, the big point that I can make today that some people will be aware of and some people won't, the big point is that the local governments take whatever the states give them. So the state has got the total control over the amount of power that the locals have. The Michigan Constitution is our plan of state government. And this is the first place you can look to determine how the government is organized, how the state is organized. And if you want to know the most about local government, you look at Article 7, which is the article that focuses on and provides the greatest information on local government organization. So Article 7, for example, creates the existence of counties, townships, cities, villages. And but again, the Constitution gives the legislature the ultimate authority to fill in the details of what each of these entities has as power over matters of quote unquote local concern. So each local government has local concern, and that is an important phrase, local concern, when it gets into certain lawsuits. And I'll mention that in just a moment. But let me talk a little bit further about the scope of each of these local governments. There's a big distinction, again, it's not always well known, between the authority of counties and townships and the authority of cities and villages. So what's the big difference? The big difference is that the authority for counties and townships is spelled out by the legislature in state laws. Now, so you look at what is the express authority given, and then there is a limited amount of implied authority as well. Now, certain counties, like Oakland County, is in a special form, and they have been permitted to have their own charter, but that is really an exception around the state. There are only a handful of counties that have that arrangement, higher population counties. But by and large, counties and townships operate only on the basis of what the state legislature has given them. Cities and villages, on the other hand, have the authority to enact charters. And local charters, of course, they follow a state law pattern in terms of what can be in the charter, what can't be in the charter, what must be in the charter. But then the people in a city or village, in approving a charter and voting to approve a charter can arrange their power to accommodate matters that are for their unique local concern. Townships and counties generally do not have that good fortune to be able to arrange things. They've got to fit into the one size fits all deal. So counties and townships get express powers from the state and powers implied. But so what is the scope of implied powers for counties and townships? Very narrow, and it's got to be traced to the powers expressly given by the legislature. So for these local governments, you've got to ask, what does the state law expressly allow us to do? So you've got that power, and then you've got implied power, but if the express power is not given, you have no implied power either in that area. On the other hand, cities and villages have express powers from the state on matters of local concern. They also have implied powers, but here's the big difference. The implied powers of cities and villages include all matters of local concern that have not been denied by the state constitution or legislation. So townships and counties is a matter of authority being given to them. And for cities and villages, it's whether or not authority has been taken away from them, as long as it deals with a matter of local concern. So for local governments that are cities and villages, what does the state law permit? Look at the charter. What power have the people approved in the charter? And then the implied powers of matters of local concern, unless prohibited by the state constitution or law. And in this situation, it's important also to recognize that that we can just say as a general matter that counties and townships, the legislature defines the boundaries of local concern. For cities and villages, the local governments participate in determining what local concern is. Okay, so now that I'm hoping that subject to your questions, that you have a better idea of what your particular local government does and can do by, you have to refer to state law for charter for townships and counties, and then of course to the charters and general laws for cities and villages. So let's turn to the Open Meetings Act. And obviously this is a really critical act that comes into play continuously for local governments. And by way of background, the reason why we have an Open Meetings Act is that for many years, actions were taken behind closed doors, you might say, in the so-called smoke-filled rooms. Decisions are made, and then the public is given only the conclusions without explanation or any reasoning, and leaving the public out, in the cold or in the dark on what really happened and why. So the objective of the Open Meetings Act was to assure the right of the public to be present for decision-making, and actually deliberations and decision-making, and to have the right to participate in that decision-making, which they didn't really have before. That's a huge step to transparency and local participation. Now, when does the Open Meetings Act apply? It applies basically to public bodies. Now, I've got the list of what courts have called public bodies. I think as an easy thing to remember, it applies to boards and commissions that make public policy for the local government. They make decisions that represent policy for the government. And so the Open Meeting Act applies to these public bodies, and it applies when a meeting of the public body is held. Now, what happens, and there are various questions about when is a meeting held. A meeting is held when there is a quorum of the public body deliberating toward public policy. So when you've got a quorum, and a quorum, of course, is the number of members of the public body needed to make a decision. So, for example, in a township, a quorum is typically 4 out of 7. And so it's generally going to be a majority. And sometimes it's the majority of people present. And for some decisions, it's a majority of the people in office. But what is a planning commission? Does a planning commission make decisions? In many instances, the planning commission is only making a recommendation to the city council, township board, village council, and so that could be a gray area. The Michigan legislature has solved that by stating in this statute that the planning commission must follow the Open Meetings Act. Now, what about situations where 2 or 3 groups get together? None of them amount to a quorum, but they get together in a scheme. So, all right, 2 of us will be here, 3 of us here, 4 of us here, and then we'll come back and then we'll have a meeting on it. Nobody will know what we've talked about. Well, that's referred to often in the court as a sub-quorum meeting, and Michigan has basically held where there's an intent to avoid the Open Meetings Act in that kind of situation. the court will call it a constructive quorum, and that can be a violation. Now, on the other hand, let's say you have a quorum present for a social gathering. Is that a quorum for Open Meetings Act purposes? The answer generally is no, because there's an exception for social gatherings. But as night follows day, quite often, a social gathering will get together, you have a quorum, and they start talking about business. Now, as soon as that group that's a quorum, not in an open session, starts talking about business, that can be a violation of the Open Meetings Act. Then you have another possibility that has an example in recent days, where you may have a group that runs as a slate to take over a public body, take over a majority of the public body, and they meet before they're sworn in to make a plan of what they're going to do. They get into office their first meeting and they make all kinds of changes. And everybody says, well, that's an Open Meetings Act violation. But then the question is always going to be relevant there. Is it if they met before they were sworn in, they're really not public officials. They couldn't even call a public meeting. So it's unlikely that that's going to be a violation of the Open Meetings Act. And that happened in Ottawa County this year, which is pretty young so far. Okay, closed sessions. So all the business of deliberating toward public policy must take place in an open session, except if the legislature has defined an exception for a particular action being taken. Now, why would the legislature do that? The legislature has found that in certain instances, very discrete instances, that there's a sufficiently strong policy reason to allow the closed session meeting. Now, and I'll talk about that a little further in a moment, but when a closed session is permitted, it's limited to discussions only. Does not permit the local body, the public body, to actually make decisions in closed session. They have to come out of closed session back into open session where the public is and make their decision. And to get into closed session, there are steps to be taken. For example, there's got to be there's a minimum vote that has to be taken, and with a roll call vote, so everybody knows who voted to go into closed session, and that kind of thing is strictly enforced. So if we're going to go into closed session, you must comply with all of those things. So I've got here in this page and the next one, and this slide and the next one, some of the grounds on which the legislature is found to be sufficient for going into closed session. And there's no strong reason for me to talk about all these things, and I want to try to finish the program. But let me talk about a couple of them. First of all, the attorney meeting with a public body. The Open Meetings Act allows that, where the attorney is going to discuss trial or settlement strategy that relates to pending litigation, not threatened litigation, but pending litigation, and to discuss a written legal opinion. Now, why would the legislature do this? For example, on the trial or settlement strategy, if that was discussed in open session, there wouldn't be much strategy there. You'd be telling the other side what you're going to do, and historically, attorneys have confidential relationships with their clients and can have this kind of discussion. Another area that the legislature has carved out would be purchasing or leasing property until an option is obtained or the basic lease terms are determined. And why, again, there you have negotiations that would take place. And so the legislature says you can't really have a negotiation if the other side knows all the things you're talking about as strategy. So the legislature has allowed this, but only until an option is obtained, or the lease arrangement, basic terms of the lease arrangement have been arrived at, and everything else then has to be in open session. Remedies for violations. This is obviously an important situation. There are three key areas here that you should know about. Number one, a party can ask the court to grant an injunction to prevent future violation. So if you have a course of events that have occurred that may leave open the possibility that this could happen again, a court might say, local government, you're prohibited from doing that. Quite often, invalidation of past violative actions, and that would be a typical kind of thing. So a local government, a quorum makes a decision outside of an open meeting, that's discovered, and the court invalidates it because it doesn't comply with the Open Meetings Act. And in these kinds of situations, there are some technical opportunities for the court to grant attorney's fees to the prevailing party if they do prevail and require the local government to act in a certain way. And attorney's fees in these situations can be very large, and local newspapers usually are good plaintiffs in these cases and can get their attorney's fees for doing this public business. A rarely used provision, and fortunately, I'm thankful that it's rarely used, is that there are criminal penalties for intentional violation. So if there's proof that a quorum of members went into a session that wasn't open to the public, made decisions and so forth, as intending to violate the act, there can be criminal penalties for that. Okay, avoiding personal liability. This is a conceptual discussion, of course, just talking about principles like all of this is on government immunity. Now, a lot of people have told me that should be chapter 1, because if you tell people what their liability is, they pay more attention in the rest of the chapters. But I made it toward the end of the book. A brief background for this, of course, is that historically kings and queens could do no wrong, and immunity was given to them for their transgressions. And as the United States came into being, that immunity was broadly transferred to US government officials as well that are carrying out the law. Over time, that immunity for local government officials began to erode. The broader immunity, total immunity, recognizing that the erosion recognizes that it deprives aggrieved parties or injured parties of relief. And in addition, insurance may apply to some of these things. So there's no great reason for allowing this total immunity picture. And so let's take a further look at this. And this subject of immunity breaks down into two categories: immunity under federal law and immunity under state law. And they're quite different, actually. And so let's take a look at the two. And the first thing is that under federal law, there is absolute immunity and then qualified immunity. Absolute immunity is a shield from, actually both of them are a shield from federal statutes that impose liability, such as civil rights statutes. So there's a federal civil rights statute, that's 42 U.S.C. 1983, that came into being in the Civil War period for violation of the Constitution or federal law. So if there's a violation of the United States Constitution, a party may bring an action in federal court in state court as well, under this 42 USC 1983 to ask for injunctive relief or money damages or both. And local government bodies, as compared to local officials, do not have this form of immunity. They do not have the this shield of absolute immunity given to officials and qualified immunity. So a local government itself can be sued if there's a transgression. Absolute immunity under federal law is given to judges, legislators, and prosecutors. And so now, judge is a broad term. You know, when you think of judges, you're thinking of the local district court, the circuit court, court of appeals, Supreme Court, and so forth. But it can include those acting in the narrative, the functionally equivalent to being a judge. Think in terms of the Zoning Board of Appeals. The Zoning Board of Appeals is frequently referred to as a quasi-judicial body. Now, if the proceeding is such that you have two sides that are fighting and the Board of Appeals is making a decision between them with testimony like you see in court and all that, a court may grant, in some cases, the Zoning Board of Appeals with this type of immunity. Legislators, including local officials, when acting within the legislative sphere, based on the nature of the action being performed. So if they're making laws, that is acting as a legislator. Now, in some instances, a township board, city council, village council person can have the authority to make administrative decisions, like in a special land use kind of situation. If the legislative body is being given the authority for the final decision on that as an administrative matter, then this immunity, absolute immunity, would not apply because they're not acting as legislators, they're acting as administrators. Likewise, prosecutors have this absolute immunity. Now, there's also something called qualified immunity under federal law. And this is something that makes an effort to balance two important interests. One would be, on the one hand, if an official is acting irresponsible. So they know what the rule is, the rule of law is, and they just irresponsibly violate it. That would be on one side of the ledger, and there's no good reason to give them immunity. On the other hand, there's a desire to shield officials from harassment and so forth when they're acting reasonably. And I'll discuss that distinction again in a moment. But just to be clear, if qualified immunity applies in a case, it will prevent personal liability for monetary damages. So it would not prohibit the grant of an injunction necessarily on further violations and things like that, but it would avoid the local official being sued for money damages. So when does qualified immunity apply? It protects from money damages if the conduct it violates an established statutory or constitutional right that the person should have known. And so if there's a rule of law on a statute or constitution and the person violates it, that qualified immunity probably will not apply. On the other hand, if there's no clearly established rule, or if there was no reasonable way the official would have known the rule, then immunity still may be applicable. I should quickly point out that the lawyers in the United States that generally represent plaintiffs in money damages cases this qualified immunity is on their radar screen to try to diminish as much as possible. So far, officials have prevailed to keep this immunity in place, and it really, there's a lot of fairness to keeping it in place, of course. All right, let's turn to state law. And the general rule here is established under a statute called the Government Tort Liabilities Act. And for this statute, the assumption is made that local governments and their officials are immune. So without, if nothing else is said, immunity will apply. So from liability, like negligence. And so as long as an official is acting within the scope of their government authority, then they're going to be immune unless this act says otherwise. And the act says otherwise with explicit exceptions to immunity when liability will apply. And there are separate rules for immunity for government agencies on the one hand, local governments, and government officials on the other. And so let's take them one at a time. Government agency immunity from tort liability. By the way, I'm sorry to go backward here, but I want to compare the federal immunity and the state immunity. The federal immunity does not apply to the government body itself. Here, under state law, the government agency immunity from tort liability will apply if the agency is exercising a governmental function. So what is a governmental function? An activity that's expressly or impliedly mandated or authorized by constitution, statute, local charter or ordinance or other law. So that's a broad explanation. And so agency liability is pretty substantial. Now, there are exceptions for the agencies, and here is a laundry list of the key exceptions that apply. You have the highway immunity or highway liability, where the highway is not being maintained in reasonably safe and convenient condition, and so that would apply to the state, of course, and also apply to villages and cities, not so much townships, because the townships really don't have roads that they're responsible for. But it does apply to quote unquote sidewalks for all local governments. And there is a very specific set of rules for when liability may arise. So you see these other rules, and they are all very relevant. I'm going to, rather than spend all the time just referring to them, I'm going to leave them to you, and turn to liability for government officials that many people are even more concerned about. And here we have immunity not given if the official is found to have been grossly negligent operating a vehicle. So the official himself or herself can be held liable if they are gross. What is gross negligence? Gross negligence would be that the person knew that they were doing the wrong thing and did it anyway. So that's like their prefrontal cortex was damaged and they can't help themselves from doing the wrong thing when they want to go 100 miles an hour in a bus. That's what they do. I don't know why I said that. Improperly providing medical care or treatment in some situations, officials not acting within the scope of authority. So if they're not doing their jobs, they're doing something else outside their public duties, and are not performing a governmental function, or again, grossly negligent acts. No absolute immunity for judges, legislators, that and elected officials, elected appointed officials, if not acting within their scope of authority. So even without gross negligence, if you're not acting within your scope of authority, no reason to give that official governmental immunity. Actions of intentional torts. Somebody punches somebody in the nose. That's not within the scope of authority, of course. Note, though, that judges, legislators, and elected officials or highest appointed officials are still not responsible here. And then a breach of contract, of course, is not within the immunity given. Okay, that is essentially the coverage today. We've got 3 more topics for next time in 2 weeks. Procedural rules for meetings, and that would be your Robert's Rules of Order or comparable rules that are adopted. Public access to governmental records, the Open Meetings or the Freedom of Information Act. And then one that's pretty meaty here. You'll have to come ready to really think hard on this: federal constitutional limits on local government. So that's a meaty topic. So I do want to say before we get to questions, because we'll probably just run out of time very quickly, and I think I'm close to being on time. I want to say that writing this book and these topics was a great pleasure. And I would add quickly, especially when all the work was done. But having the opportunity to share this material with you today is an extension of that pleasure, and I really appreciate that opportunity. My email is on these materials, and if we don't get to answer a question that you have, feel free. I invite you to send me an email, and I'll do my best to respond in a reasonable amount of time to get your answer to you. And so I want to thank you, and please enjoy your local government service. So I'm ready for questions, Jim.
Okay, excellent, Jerry. Thank you very much. Yeah, if you do have questions, go ahead and put them in the chat, direct them to me, and then I'll get them to Jerry. So we do have quite a few. So first off, Jerry, do you think each member on a board should speak specifically to the reason why they are voting a certain way on topics when they actually cast their vote?
This would be in general terms, or
I think generally,
okay.
basically, should you speak to the reason why you're voting the way you are when you cast your vote?
Okay, so the question is, should you do that? There's absolutely no obligation, morally or otherwise, to do that. You're just voting, and in many instances, without a roll call vote, nobody will even know how you voted, for sure. But and this is a big difference between making certain decisions or making a decision that's administrative by the whole body. And let me just quickly say that where an administrative decision is made, like granting a special land use, denying a special land use, that there's an obligation to state your reasons for doing that. But it should be in the motion itself, not necessarily individual officials stating their reasons for why they're voting. And not that an official has no right to state their reasons. They certainly, unless there's a procedural rule in the local government, you have every right to do that. But in terms of legislation, making legislation, there's no obligation to state any reason for why the legislation is adopted. In some cases, reasons are put in the legislation itself, which is fine, and that would help the court and help parties. But so that's a big difference between administrative and legislative.
Okay, good. Jerry, if you could take your slideshow down to the thank you slide, the last one, that'll have people able to get your contact information while we're talking. Good, thanks.
Yeah, thank you.
The next question, can you confirm that the public can come to any commission, board, committee, and subcommittee meetings?
Yeah, I'm sure that in general is true. Now there may be some. Now this would be these meetings that you're talking about, subcommittees and so forth, that are open to the public. In other words, that are public meetings.
Well, the question is, can you confirm that the public can come to any commission, board, committee, or subcommittee?
Yeah, and I guess I cannot say that. It would be the public is entitled to attend any meeting of a public body. I think that's the best way to say it. And I've got the various criteria for public body in one of the slides. But if it's not a public body, then they're like a committee. Let's say, for example, the mayor of a city or the supervisor of a township appoints a committee. So the board doesn't do the appointing. Just an ad hoc committee is appointed by the mayor or the township supervisor. That would not, in all likelihood, be a public body, and so the public may not have a right to attend those meetings unless they're invited. On the other hand, if the body is established by constitution, law, etc., ordinance, or if the whole township board establishes that body, or the city council or village council establishes that body, then it is a public body and the public has a right to attend. I hope that cuts up, that divides the two areas.
Very good. Are group emails, text, etc., also subject to Open Meetings Act?
Absolutely. Yeah, absolutely. And there was an Ann Arbor case on that where members of the city council were emailing during a presentation. You know, they've got their laptops at their desks during the meeting, and they're emailing back and forth, and because a quorum engaged in the process, that was considered to be an Open Meetings Act violation.
Okay. Can a city pass charter provisions that conflict with an express state statute that addresses the same subject matter?
And now that gets a little more complicated, but the instances in which that cannot happen is where the state has given its intent to cover that whole field. So the state may impliedly or expressly take the position that its rules are preempting all other rules. The second level would be where the state statute says, here's what you can't do. And if the local government says, well, we don't care what the state says about that, we're going to say you can do it anyway. And that would be a violation. That the local government cannot do that. On the other hand, if the state by statute sets a limit for, let's say, for you've got to have at least 5 members on this kind of committee, that doesn't close the door to local action. And if the local action does not basically go against the state law, but creates, in some cases, maybe more of a strict requirement. For example, in wetlands, in some cases, a wetland rule may be more strict than the state Wetland Act. And obviously there are going to be some gray areas in these circumstances, but generally speaking, preemption would not apply as long as it's not contradicting a directive of the state law.
Okay. In discussing the Open Meetings Act, you mentioned social gatherings and used the word talking quote unquote business, but there are different types of business, and the statute addresses decisions related to public policy. Can a quorum of a planning commissioners hold a training session which is general in nature, unrelated to any particular application or type of application.
And by type of application, I assume that type of application that's relevant at the time. And I think the answer is yes, that a training session, and I can't recall the exact language in the statute, but I think I think something like educational sessions are an exception to the rule, as long as you're not talking about, and I guess this is where the question was going, you're not talking about a case that you have before you. So I mean, you can't have a training session called that then focuses on a case that you have before you, and you're not an open session. So that's a problem. But if it's just in terms of general principles, I think it's fine.
Okay. Will the recording, this is actually for us, Jerry, will the recording of this presentation be available? The answer is yes. We will send you all the link when it's posted to our website. Another question is, how do you obtain a copy of the book that's referred to in this session? The first slide had the title, Local Government Law, Practical Guidebook for Public Officials, City Councils, Community Boards, and Planning Commissions. It's also in all of the promotional information. If you just search that, several different sources will pop up for purchase.
And Amazon has it, and the publisher Routledge has it.
Okay. Another question for you, Jerry. Do counties have the ability to create policies or mandates that need to be followed by cities and townships?
So that would only apply, the counties have their sphere of authority. Cities, villages, townships have their sphere of authority. And if the county's action gets into the city, village, township sphere of authority, then no, the county does not have the ability to do that. But if it's in the county's sphere of authority and it's not otherwise covered by the city, village, township, then they can.
Okay. Are school boards subject to the same Open Meeting Act rules and penalties for violations?
Yes. Yeah, that's an easy one.
All right. What about a subcommittee handling personnel issues, such as union contracts? That's the question, but I'm assuming they're referring back to the issue of Open Meetings Act.
Yeah. So you have that kind of subcommittee. If it is an official subcommittee created by the city council, township board, or village council, then I think an argument can be made that that is a public body. And that's the way I read that statute, if you're going to be careful with it. But if it's an informally created body by the chief executive officer, like the mayor or the township supervisor, then I think there's an even stronger argument that it's not subject to the act. Okay. And you know that, and let me add one further thing to that. That presumes that this body is not actually making decisions that are binding on the ultimate decision maker. So if, for example, there is a grievance or whatever filed, and this body says we're going to determine that there was no grievance, that's actually a decision. And I would say that you'd have to be careful, very careful on that one, as being an Open Meetings Act issue.
Okay. What are the circumstances where a public body does not have to publish a regular meeting schedule?
The regular meeting schedule? Well, obviously for special meetings and emergency meetings, there's no need to publish that in advance. I think the act requires a publication of all the regular meetings that are, the schedule of regular meetings for the year, and probably any other special type meetings that you know about. But otherwise, it would be impossible to always give notice like that, other than the 18-hour advance notice that is required in the statute.
Okay. we as commission members are not allowed to attend subcommittee meetings for things which may come before us. It is accurate to say that our very presence as commissioners or elected officials can change or impact, potentially affect the open discussion of decisions. It's more of a statement than a question, but maybe you want to comment on that.
Yeah, and I think that is reflected in various cases that where the appointing body, in other words, if the members of this group are appointed, those people that are doing the appointments should not appear at a meeting, and unless it's the end of somebody's term and they're never going to get a chance to do another appointment, then it is probably not as relevant. But you know, I guess the language of the question goes a little further than I would take it, and it sounds like this rule is maybe made part of the rule of procedure in that local government, which is probably going to have more binding effect, but prohibiting officials from merely attending the meeting, I've never seen any rule of law in a case or otherwise that would prohibit merely attending a meeting.
Yeah, they did add to the point of clarification that yes, we are the appointing body.
Yeah, but even if it's an appointing body, then I think the problem arises when they're advocating. If especially where there's a close decision made and the person on the legislative body stands up or the appointing body stands up and pushes it over onto one side or the other, that's probably a problem. But if they're merely sitting alone or with just a couple people in the meeting, that's not a state law problem.
Okay. Well, we are up against our 1 o'clock time frame. Jerry, want to thank you for an excellent presentation and remind everybody that our next session will be Thursday, January 26th from noon to 1 p.m. And you can use the exact same link to jump onto that session. We will also be sending out reminders on that as well. So thank you very much for attending. And as Jerry mentioned, you can do follow-up questions with him. His contact information is available there on the slide. Jerry, if you can hold on for a minute on the Zoom while everyone else exits the room. Thank you very much. Have a great day.
Thank you, everybody.